As we said to the court, and as the trial judge said, that's the most difficult part of the case. We say that it was proven by circumstantial evidence. And the circumstantial evidence is, one, as you heard in there just now, we identified a document that was actually prepared by MMR's expert for telemedia, which shows that telemedia was working with MMR for MMR to get ahead in the project that they were developing. We also say that the email on the 7th of August 2014 from Ms. Wilson to Mr. Swayze was a lie, because what she said was that your project will not be launched this year because it didn't fit into the company's strategy. But a couple months later, McMurrich was launched, and so they lied to Mr. Swayze and then launched McMurrich. And the question is, well, why lie if you're acting above board? This is not a case of breach of copyright. It's a breach of information. I am supplying information to you that you and I have agreed is to be kept confidential. And the question is whether or not that information was disclosed to MMR. It is not a question of copyright where somebody is proving that I have invented something and that you are, trading off the invention that I have made. So it's a very different tort, and we are not attempting to satisfy the court that Mr. Swayze invented SMS messaging, or that this is the first time anybody has ever had a case where you have a lottery, by texting. What he's saying is that his work with respect to texting of lottery in Belize was designed by him, and he provided that information to telemedia under the agreement, which was to be kept confidential, and they breached it. So it's different from copyright.